union's ability to demand that financial support. Instead, employees would now only need to support a union by their own will. So what that kind of brings about is there's a rub between employees that are included in a union. You've got coworkers where some are paying their dues and some aren't, and so that can create some issues within the organization. So according to the defendant's brief, the Taylor collective bargaining agreement had for, I guess, about 40 years a provision generically known as the Union Security Clause, and also called an agency fee or a fair share clause. Such articles they're really common in both public and private sector agreements. The parties had long agreed that the members of the bargaining unit would be required to either become members of the labor organization or to pay a fee representing the costs associated with contract negotiation and administration. A union security clause is intended to prevent what are called free riders, so those people that aren't paying their dues. Without such provisions, a person who's a member of a bargaining unit may seek to receive all the benefits of the collective bargaining agreement without providing the financial support necessary to bargain contracts or enforce them. So it is something, like I said, that does come up. So moving on to slide 11, the agreements in question. So just to explain what exactly those are. So according to the plaintiffs, to the three teachers, in order to counter the new legislation of the Right to Work law, the Taylor School District and the Taylor Federation of Teachers Local 1085 negotiated two agreements as they felt that they, did this quickly and without consideration. And one of those agreements was a 4-year collective bargaining agreement that replaced a contract that had expired back in 2011. And the second is a 10-year union security agreement under which Taylor teachers are forced to pay union dues or fees for the next 10 years. The timing of these agreements lock the teachers into paying dues to the union for 10 years, and it avoids a portion of the law that requires right to work to take effect anytime a collective bargaining agreement is extended, renewed, or amended. The agreements were negotiated and signed between the time that the Right to Work law was passed and enacted. So it happened within that time frame, those 3 months between December and March. So actually the next slide, I just put up a timeline so we can all understand kind of how this played out. December 11th, 2012, that is when Michigan passed the Right to Work law. In February 5th and 6th, that's when the union signed those two agreements. And by February 28th, the teachers filed suit, with a month later the Right to Work law going into effect. So looking at the questions in this case presented by both parties, and to kind of evaluate and analyze really what's going on here and if they have a case, in my opinion. We talk about here, is the contract valid? So have the 4 requirements of the contract been met? What value do the agreements bring to the school district? That's something that came up. If it's one-sided, it wouldn't be necessarily valid. So is there a value to the school district? Does the contract lack consideration based on the motives of the union? Again, that was a big one on the side of the plaintiffs. Are the plaintiffs parties of the contract? And lastly, although voluntary consent was present between the district and the union, where is the line drawn regarding voluntary consent of the people that the union officials represent? So what value do these agreements bring to the school district? Well, if you actually dig deeper into this case, I read thoroughly the defendant's brief, and there's quite a bit more information and things going on here, but I tried to keep it kind of high level just to focus on the contract formation. But if you dig deeper, there was a lot more included in the agreements than just what the plaintiffs are claiming, and it actually took place for quite a while. The agreements included actually pay cuts for the teachers because the school district is having some financial issues. So it did include quite a bit of detail about expenses and other things they were going to cut, including salaries. And the agreements were negotiated for nearly 3 years. So I would have to say that yes, the agreements did bring value to the school district because at the end of the day, they were saving money. And the fees, union fees and whatnot were only a portion of what was included in the agreement. Does the contract lack consideration based on the motives of the union? If there were no other components to the agreement other than the collective bargaining and union security clauses, then I would suggest that there was a lack of consideration and thus the contract is not valid. But considering the union was not just securing the last minute petition for a mandate of fees, as was implied by the plaintiffs, I do believe there was conscious consideration of the terms of the agreement. The other 3 requirements of a contract, the agreement, contractual capacity, and legality, those were met. Again, consideration is promises made by the parties and must be supported by legally sufficient and bargained for consideration. Also, the second requirement of an offer includes identification of the parties involved, which clearly here was the school district and the union. Those were the parties involved. Collective bargaining states that the union is the exclusive bargaining representative of the workers, which would imply that by signing the contract, they are signing on behalf of the workers. So are the plaintiffs the parties of the contract? I would suggest they're not. And I don't believe that the argument by the plaintiffs would work in court because they have essentially said that the union is their representative and they will sign on their behalf. Lastly, the voluntary consent, I think that goes along as well with the fact that by joining the union, they are allowing the union officials to be their representatives. Remember, unions are a voluntary organization to join. They are not required to join the union, but really what this is talking about is if you are a part of a union, are you required to pay fees? I would suggest that you should be. It just only makes sense, and if you don't want to join the union. But so my opinion is that honestly, the best case the plaintiffs have to win the argument is to argue that there was a lack of consideration and thus the contract is invalid. However, I think that's going to be difficult because the actual parties signing the contract, they do have good evidence to prove that they did have consideration. And the plaintiffs lack standing to challenge the terms of the collective bargaining agreement because they're not the parties to it, and the union officers have exclusive rights to bargain on their behalf. So I hope everything made sense, and if you have any questions or comments, want to reach out to me, please feel free. I'm available. So thank you very much, and see you guys later.